What if you woke up tomorrow and discovered you were being sued? Not because you did anything wrong, but just because you were in the wrong place at the wrong time. A questionable car accident claim. A disgruntled ex-employee. A tenant who slips and falls. Suddenly, everything you've worked so hard for, your home, your savings, your business, is on the line. It's a juicy target for a plaintiff's attorney who sees you as a walking dollar sign. For most people, this is a terrifying, life-altering nightmare. But for a certain class of the wealthy, it's just a nuisance. Why? Because when the lawyers come looking, they find nothing. The house isn't in their name. The brokerage account has vanished. The business is owned by a structure they can't possibly penetrate. It's as if their wealth is a ghost in the machine, completely shielded, completely untouchable. They own everything, but their name is on nothing. Imagine a world where you are that ghost. A world where predatory lawsuits and aggressive creditors just pass right through you, unable to get a grip. For the ultra-wealthy, this isn't imagination, it's a financial reality, built with precision and foresight. They use a completely legitimate legal framework, a fortress of entities and trusts, that makes their assets invisible to the outside world. I'm an attorney, and for years, I've helped clients build these very fortresses. This isn't about hiding from your real obligations. This is about smart, proactive planning. It's about recognizing that in our lawsuit-happy society, visibility equals vulnerability. Today, I'm not just going to tell you that the rich do this. I'm going to show you how they do it. I'm giving you the blueprint, the step-by-step guide to transforming yourself from a financial target into a legal ghost. We're going to build your fortress, level by level. Section 1, the problem, why you're a target. Before we can build, you need to understand the battlefield. Your single biggest financial risk today isn't a stock market crash or a bad investment. It's a lawsuit. In the United States, tens of millions of lawsuits get filed every single year. Many are frivolous, designed from the get-go to bully you into a settlement because fighting is just too expensive and time-consuming. When a plaintiff's attorney is deciding who to sue, what's the first thing they do? They run an asset search. They look for your name in public records because they want to know what you own. Do you own a home? Is there equity in it? Do you have a brokerage account? Do you own a business in your personal name? Every single asset tied directly to your name is a flashing neon sign that says, "Sue me. I'm collectible." You've essentially taped a target to your back. The more you have in your name, the bigger that target gets. They see a person with a $2 million house, a stock portfolio, and a couple of rental properties, and their eyes light up. They know that even if their case is weak, the threat of taking all of that is often enough to force a handsome settlement. This is the fundamental problem with traditional ownership. You work your whole life to build wealth, only to have that wealth make you a magnet for legal predators. Your success becomes your liability. The system actually encourages this. It's designed to find the path of least resistance to the deepest pockets. So, how do you opt out? You don't do it by hiding cash under the mattress or getting into illegal schemes. You do it by legally changing the rules of the game. You do it by systematically decoupling your identity from your assets. You start building your fortress. But, and this is critical, asset protection is not a reaction to a crisis. All the strategies we're about to discuss must be implemented in peacetime, that is, before a claim or lawsuit ever pops up. If you try to move assets after a threat emerges, a court can call it a fraudulent transfer, reverse the whole transaction, and you could face severe penalties. Let's start with the foundation. Section 2, Level 1, the Invisibility Cloak, achieving basic anonymity. The first step to becoming a legal ghost is to simply disappear from public records. We need to wrap your assets in an invisibility cloak, so when someone runs that initial, superficial asset search, your name comes up with, well, nothing. On paper, you own nothing. We pull this off with two foundational tools, the land trust and the anonymous LLC. Let's start with your most visible asset, your home. If you own your home in your own name, you're advertising its equity to the entire world. A simple property search reveals your name, your address, and the home's value. That's low-hanging fruit for a creditor. The solution is a land trust. A land trust is a simple, private agreement where you transfer the property's legal title to a trustee. The trustee can be a trusted friend or a professional company, but you, as the beneficiary, keep all the control. You can live in the house, sell it, mortgage it, everything. The only difference is that the public record, the deed, no longer shows your name. It shows the name of the trust, like the 123 Main Street Trust. Now when that lawyer does a property search, they don't see John and Jane Smith living in a valuable home. They see a trust. Who's the beneficiary of that trust? That information is private and not part of any public record. You've just taken your single biggest asset off the board. You've become invisible at your own address. That's a powerful first step, but what about your other assets? Your investments, your brokerage account, your savings? This is where the second tool comes in, the anonymous LLC, specifically one from a state like Wyoming. While many states have LLCs, a few like Wyoming, Delaware, and New Mexico have laws that are exceptionally friendly to privacy. Wyoming is a standout because it doesn't require the names of the LLC's members or managers to be listed in public filings. When you form a Wyoming LLC, the public documents only need to list a registered agent. Your name appears absolutely nowhere. Now, it's true that a recent federal law, the Corporate Transparency Act, requires this ownership information to be reported to a confidential government database, FinCEN, but the key is that it remains hidden from the public eye and from snooping lawyers. So, picture this, you form Apex Holdings LLC in Wyoming. You then open a bank account and a brokerage account in the name of that LLC. You transfer your stocks, bonds, and savings into those accounts. You own the LLC, you control it completely, but your name isn't publicly tied to it. From the outside, it's just some anonymous company. Suddenly, you look like a much less attractive target. The cost and effort to sue you have just gone up exponentially. They'd have to file lawsuits just to try and figure out what you own. Most will just give up and move on to an easier target. That's the power of level 1. It's about creating friction and obscurity by legally privatizing your ownership. You've put on the invisibility cloak. But that's just the beginning. The cloak makes you hard to see, but a determined attacker might still find you. To become truly untouchable, we need to build walls. Section 3, Level 2, the Fortress, isolating assets with Series LLCs. Level 1 made you invisible. Level 2 is about making you indestructible. This is for anyone with multiple assets, especially ones that carry their own liability, like rental properties. The guiding principle here is asset isolation. The goal is to make sure that a problem with one asset can never, ever threaten your other assets. Take a real estate investor. Let's say you own 3 rental properties. A common, and very dangerous, mistake is to own all 3 in your personal name, or even under a single LLC, let's call it Smith Rentals LLC. It seems smart, separating business from personal, but what have you really done? You've put all your eggs in one basket. Imagine a tenant at property A slips and sues. They don't just sue for the value of property A. They sue Smith Rentals LLC. And what does that LLC own?
It owns properties A, B, and C.
A single lawsuit from one property now threatens the equity in all 3. You've created a single point of failure. One lawsuit could wipe out your entire portfolio. This is where the Fortress strategy comes in, using the perfect tool, the Series LLC. A Series LLC is one of the most powerful and efficient asset protection tools out there. Think of it like a filing cabinet. The parent LLC is the cabinet, and each series is a separate, lockable drawer inside. Several states, like Delaware, Texas, and Nevada, have pioneered this structure. Here's how it works. You establish one parent Series LLC, let's call it Fortress Holdings, a Series LLC. This parent LLC doesn't own anything directly. Instead, you create separate, internal series under it. You'd create Series A to hold rental property A, Series B to hold rental property B, and Series C to hold rental property C. By law, each series is treated as a separate entity for liability purposes. This is the magic. The liabilities of one series cannot cross over and attach to the assets of another series. They're like internal, legal firewalls. Now, let's replay our scenario. The tenant at property A slips and sues. Who do they sue? They can only sue Fortress Holdings, Series A. The lawsuit is completely contained within that series. The only asset at risk is property A. The assets held in Series B and C are totally shielded, untouchable. A fire in one drawer doesn't burn down the whole cabinet. This structure is profoundly powerful. Instead of forming and paying annual fees for 3 separate LLCs, you have one parent company with internal divisions. It's more efficient and provides a level of compartmentalization that is simply unmatched. To make it even stronger, The parent series LLC itself can be an anonymous Wyoming LLC. So the whole structure is anonymous, and each asset inside is isolated. With level 1, you became invisible. With level 2, you've contained any potential threat. You've built the outer walls and the internal bulkheads. But what if a creditor manages to breach a wall? What if they win a judgment? Is the asset lost? Not if you've built level 3. Section 4, Level 3, the Untouchable Ghost, Advanced Charging Order Protection and Domestic Trust. Welcome to Level 3. This is where we go from basic defense to nearly impenetrable protection. We're going to turn your assets into something a creditor can see, but cannot seize. This level is built on 2 pillars: understanding charging order protection and using domestic asset protection trusts, DAPTs. First, the charging order. It's the most important concept in LLC asset protection. Remember our Series LLC? Let's say a creditor wins a lawsuit against Series A. Their first instinct is to say, "Great, I won. Sell that property and give me my money." But in states with the strongest asset protection laws, like Wyoming and Nevada, they can't do that. The law says that for an LLC in these states, the exclusive remedy for a creditor is a charging order. Exclusive is the key word. It's the only thing a court can grant them. So what is a charging order? It's simply a lien on distributions. It gives the creditor the right to receive money if and when the LLC distributes it to you. That's it. They don't get to vote in the LLC. They can't become a member. And most importantly, they can't force you to sell the property or make a distribution. Think about what that means. You, as the manager of your LLC, are in control. The creditor has a judgment, but all they can do is sit and wait. So, you simply don't make any distributions. You let the profits build up inside the LLC. You can use the money for LLC expenses, repairs, or reinvestment. As long as you don't pay yourself, the creditor gets nothing. They're stuck. And it gets worse for them. There's a concept in tax law called phantom income. Because an LLC is a pass-through entity, profits are taxed at the member level, whether they're distributed or not. So at the end of the year, the LLC issues a K-1 tax form to its members. And to the creditor holding the charging order. This means the creditor could actually get a tax bill for profits they never received. They're now in a position where they get zero cash, but they get a tax bill. This is a creditor's worst nightmare and an incredibly powerful negotiating tool. Most will be highly motivated to settle for pennies on the dollar just to make the headache go away. Now, for the second pillar, the Domestic Asset Protection Trust, DAPT. For decades, you couldn't create a trust to protect your own assets from your own creditors. But now, nearly 20 states, including South Dakota, Nevada, and Delaware, allow you to create an irrevocable trust for your own benefit that's shielded from your future creditors. Here's how it works. You, the grantor, create an irrevocable trust in a DAPT state and transfer assets into it. You can be the beneficiary, meaning you can still receive distributions. After a waiting period, typically around 2 years, the assets inside the trust are legally protected from your creditors. Think of the structure: your anonymous Wyoming Series LLC, with all its charging order protection, has its ownership held by a South Dakota DAPT. A creditor is now facing a labyrinth. Even if they fight through the courts and discover the trust, they have to go to a South Dakota court to try and break it, where the laws are designed to protect it. And even if they could somehow attack the LLC inside the trust, they'd still only get a charging order, which we've established is practically worthless. You've built a fortress within a fortress. Section 5, Level 4, the International Phantom, the ultimate shield of offshore trusts. We've now reached the apex of asset protection. Level 4 is not for everyone. It's complex, it's expensive, and it means moving beyond US borders. This is the world of offshore asset protection trusts, specifically in jurisdictions like the Cook Islands and Nevis. Why go to this length? Because these small, sovereign nations have built their economies around creating the most legally impenetrable asset protection vehicles on the planet. They wrote their laws with the specific goal of making it nearly impossible for a foreign court, including a US court, to enforce a judgment against assets held in one of their trusts. Here's the fundamental difference. With a US trust, a creditor can take a California judgment to a South Dakota court and try to enforce it. They'll probably fail, but they're still in the US legal system. The Cook Islands, however, is a separate country. It does not recognize US court orders. If a creditor shows up there with a US judgment, The local courts will essentially ignore it. To get to the assets, they have to start their entire lawsuit over again, from scratch, in a Cook Islands court, under Cook Islands law. And the laws there are designed to be a nightmare for creditors. Insane burden of proof. To prove a fraudulent transfer, a creditor must prove it beyond a reasonable doubt, the same standard as a U.S. murder trial. It's an almost impossible bar to clear. Short statute of limitations. The window to even bring a claim is incredibly short, often just 1 to 2 years from when the assets were transferred. Miss that window, and the claim is dead forever. Duress clauses. These trusts are built with duress clauses. If a U.S. judge orders you to bring the money back, the foreign trustee is legally forbidden from complying. You can honestly tell the judge, "Your Honor, I told them to send it back, but they refused." This can help you avoid being held in contempt, because you are factually unable to comply. The assets remain safe offshore. The ultimate structure might be a Cook Islands trust that owns a Wyoming LLC, which in turn holds all the assets. A creditor now faces a battle so expensive, so uncertain, and so frustrating that virtually no one will even try. This is the nuclear option. It makes your wealth a true international phantom, existing in a legal dimension beyond the reach of the U.S. court system. We've journeyed through all 4 levels of the legal ghost fortress. The tools are powerful, but they are just tools. Strategy and execution are everything. Before you do anything, you must burn 2 rules into your mind. Rule number 1, the peacetime rule. I'll say it again because it's that important. All of this planning must be done when the skies are clear. Transferring assets to avoid a known creditor is illegal. A court will just unwind it, and you'll have wasted your time and money and could face serious penalties. Rule number 2, this is not a DIY project. We've discussed complex legal structures spanning multiple states and countries. The laws are constantly changing. A poorly drafted document can leave a crack in the armor that a good lawyer will drive a truck through, rendering your entire fortress useless. You must work with experienced legal and tax professionals who specialize in this. If what we've talked about today resonates with you, if you feel that vulnerability that comes with having your assets exposed, I encourage you to take the first step. Click the link in the description to schedule a free consultation with our team. We can help you figure out what level of protection is right for you. Don't wait for the storm. Becoming a legal ghost isn't about evading your responsibilities. It's about taking control. It's about refusing to be an easy target in an increasingly litigious world. It's about structuring your affairs with the same sophistication the world's wealthiest families have used for generations. By layering these strategies, anonymity, isolation, and advanced legal shields, you transform your financial profile from a visible target to an untouchable entity. You own everything, but your name is on nothing. You've become a ghost in the machine. Now is the time to build your fortress.